Today I want to go over a story that's been going around in the New York Post. There's a big divorce going on right now with about $100 million worth of assets, just typical everyday run-of-the-mill type of divorce. We have billionaire investor Michael Fisch struggles to keep cool at explosive NYC divorce hearing. So I read this article and, although it definitely touches on some pretty novel type of reasons to be upset, it actually does translate to a lot of just typical divorces. So a little bit of background. You have this guy over here, Michael Fisch. Him and his wife, Laura Roberson-Fisch, a very wealthy couple. Mr. Fisch runs or is in charge of a hedge fund here in New York City, manages approximately $7 billion worth of assets. So as you could imagine, probably gets paid, handsomely. Very high level skill here. The assets that this couple is kind of quote unquote fighting over is somewhere north of $100 million. So we're talking about seemed to me like there was a lot of emotion involved, a lot of yelling. Seems like some very, highly charged attorneys, really trying to advocate for their client's position. The wife has alleged that Mr. Fisch has taken, very expensive artwork and moved it or sold it, or something's going on. They have a mansion that she's been very upset about the fact that he's had various women or unknown people staying over at that mansion while they're still married. They seem to have some sort of arrangement where they do like a week on, week at that property. Here's her quote: "He won't even agree not to bring women into the bed where she sleeps on alternating weekends," said Miss Roberson-Fisch's attorney, Jonathan Wolf. So the parties here have a beautiful property here on Hampton on Further Lane, known as Billionaire's Row. So what are they fighting over, right? Should be pretty straightforward. You guys have a ton of money. There's no prenup. Split it down the middle. Well, when you have this level of assets, you have to ascertain what the actual assets are and what is subject to distribution. Not necessarily everything that was earned during the course of the marriage is marital property, although most of it probably is. The controversy here, and this case is in Manhattan in front of Judge Ariel Kessler, has been contested since about April of 2022. I'm sure it's been in the papers here and there. Actually, first time I'm hearing about this particular case. But the issue that seems to be what they continue to go back and forth on is the issue of discovery. And that's where it actually comes more into play about a typical divorce, just your average run-of-the-mill divorce where a couple has, bank accounts, retirement assets, things of that nature. So what are they fighting over, right? So the wife here is fighting over just various records, and Mr. Fisch is extremely upset, saying that she's embarking on a fishing expedition. Fishing expedition in law, for those of you that are not familiar, is when someone just floods you with demands. They don't even know what they're looking for, but they're looking for something. So they send out a ton of demands. They want all the documents. They're going to go through it. Is it relevant? Is it not relevant? To be determined, right? So going back to this, the wife seems to be demanding records of his private spending after the filing of the divorce. Basically, the husband is arguing that this is meant to annoy and to harass him, and that it's really for the purpose of just looking through and being invasive into his life and seeing, why does it matter how much he pays the guy that, the gasses up his private jet? These are not things that perhaps are relevant here. So in a typical divorce, what is discoverable? The answer to that might be surprising. The answer to what is discoverable in a typical divorce is pretty much everything. There is a allowance for broad discovery in matrimonial actions in New York State, meaning that although we generally go back about 3 years because that's the most recent and most relevant information, we can go back to the beginning of time. We generally don't, but the longer the marriage, we might go back in time 10, 15, 20 years if we need to find out certain information that might be relevant, to determine if an asset is separate, to determine if marital assets were used for the purchase of something or the maintenance of some sort of asset. So the court really does allow for broad disclosure. Does it allow for disclosure during the pendency of a divorce of, what's been spent after the divorce has been filed? Yes, it does. But the answer is really, it depends. It depends on whether marital assets are being dissipated following the filing of a divorce for various non-marital expenses or not status quo. It could also be to show that some sort of contribution was being made from separate accounts into marital accounts or vice versa. There's all sorts of things. So there really is an ability to continue to ask for records as much as you need. Do you have to? Absolutely not, because the more discovery you go through, the more money you're going to spend as part of your divorce. And your ultimate goal is always to reach as simple and as effective of a resolution as possible. You're not looking necessarily to see how many times your spouse ordered Uber Eats, but you're probably looking at whether they've spent money on any debts that maybe you weren't aware of, maybe if money was transferring in and out from accounts that you weren't familiar with. There's a lot of different things that come up when it comes to the context of financial disclosure. So in most cases, you're going to start out with listing your assets and liabilities. So although you might not be living on Further Lane on Billionaire's Row, but your asset will have to be disclosed. You're going to have to disclose all of your bank accounts, your debts, loans that you have, whether they're promissory loans or mortgages, school loans. It turns out that when you're in a divorce, everything is on the table. You have to disclose absolutely anything and everything that you've either gained, acquired prior to or during the marriage. So if there's an expectation that you're not going to show anything to your ex, you have to get that out of your head, because you're going to have to disclose your assets. And most commonly, I'll get a call or someone tells me that they have no idea what their partner has and what kind of assets are relevant here. So ultimately, what does all of this mean? It means that be prepared to disclose your assets, be prepared to sift through your partner's financial disclosure, bank accounts, credit card statements, brokerage account statements, in order to determine what is subject to equitable distribution. My name is Leon Mindin. I'm a New York City divorce attorney covering divorces, family law issues. If you need assistance, check out the description, contact us, schedule a free call with my team. Looking forward to speaking to you.